Case Law No. 07/2016/AL on recognition of contracts for sale and purchase of house entered into before July 1, 1991. Including 5 parts: Part 1, Source of the Case Law; Part 2, Overview of the Case Law; Part 3, Content of the Case; Part 4, Assessment of the Court; Part 5, Rules. This case law number 07/2016/AL was adopted by the Judicial Council of the Supreme People's Court on October 17, 2016 and promulgated under Decision number 698/QDCA dated October 17, 2016 by the Chief Justice of the Supreme People's Court. Cassation Decision number 126/2013/DSGDT dated September 23, 2013 of the Judicial Council of the Supreme People's Court on disputes on the rights of ownership and use of house in Hanoi, in which Mr. Nguyen Din Song, Ms. Nguyen Thi Hong, and Ms. Nguyen Thi Hong are the plaintiffs and Mr. Du Trong Ton, Ms. Du Thi Ngoyet, Mr. Vong Chi Tuong, Mr. Vong Chi Tang, Ms. Vong Bich Van, Ms. Vong Bich Hop are the defendants. The parties with related rights and obligations include Ms. Nguyen Thi Lon, Ms. Nguyen Thi Hay, Ms. Ta Thi Lam, Mr. Nguyen Din Yuan, Ms. Nguyen Thi Hop, Mr. Nguyen Din Hoa, Ms. Nguyen Thi Min Ngoyet, Ms. Tran Thi Bich, Mr. Vu Din Hao. Part 2, Overview of the Case Law. Where a sale and purchase contract of a house was made in writing before July 1, 1991, which was signed by the seller and noted that the seller received payment in full. The buyer did not sign the contract, but she kept the contract, managed and stably used the house over the long period without any dispute of payment. In this case, the contract will be proofs of the full payment of the buyer to the seller and the intention of the buyer to agree with the sale and purchase contract of the house. Therefore, the contract will be legally recognized. Applicable provisions of laws relating to the case law. Articles 81, 82, and 83 of the Civil Procedure Code 2004, corresponding to Articles 93, 94, 95 of the Civil Procedure Code 2015. Resolution number 58/1998/NQUBTVQH10 dated August 20, 1998 of the Standing Committee of the National Assembly on Civil Transactions of House entered into before July 1, 1991. Key words of the case law: contracts for sale and purchase of house. One party does not sign the contract. Verifying evidence. Part 3. Content of the case. Pursuant to the Statement of Claims dated March 6, 2016, and in the process of handling the dispute, Mr. Nguyen Din Song is the plaintiff presented. His father is Mr. Nguyen Din Chien, passed away in 1998, and his mother is Ms. Nguyen Thi Mo, passed away in 2005. His parents had 4 children consisting of Mr. Song, the plaintiff, Ms. Nguyen Thi Hong, Ms. Nguyen Thi Hong, and Ms. Nguyen Thi Lon. Previously, his family lived at number 2 Hang Bun and Mr. Nguyen Din Nguyen being his elder uncle lived at number 10 Hang Bun. After his uncle returned from an evacuation, the state took his uncle's house and assigned it to another person for use. As such, his father gave house number 2 Hang Bun to Mr. Nguyen and his father's family rented a house elsewhere. Since Mr. Chow needed money for medical treatment, Mr. Chow sold a room of 38 square meters on the second floor of the house number 19 Thuoc back to his family. The contract signed by Mr. Chow did not contain date. It stated the price of VND 6,550 and Mr. Chow received payment in full. When Mr. Chow sold the room of 38 square meters, Mr. Chow gave his father the land title of the house number 19 Thuoc back, which recorded that Mr. Chow was entitled to 8/12 of the house. And the remaining parts of the house, for 12ths, are owned jointly by Mr. Ton, Ms. Na, Ms. Noyet, and Ms. Tone. Previously, Mr. Ton and his siblings had sold the first floor of the house number 19 Thuoc back to the wife and husband Mr. Vu Din Teep and Ms. Tran Thi Bich. Mr. Chow renovated the kitchen of 7 square meter on the second floor as his residence. After Mr. Chow passed away on November 5, 1972, Mr. Tan and his siblings being Ms. Na and Ms. Noyet sold entirely the area of 7 square meter on the second floor to his family with the price of VND, 3,000. And the sellers legitimated the transaction via a contract dated November 5, 1972, being the day Mr. Chow passed away, on the sale of the entire second floor. Mr. Tan and his siblings together signed the contract, which clearly stated that the sellers received the payment in full. Mr. Tan also handed over the power of attorney dated September 9, 1972 of Mr. Chow, having the contents that Mr. Chow is the owner of the house number 19 Thuoc Bac. Due to Mr. Chow being sick, Mr. Chow made this power of attorney authorizing Mr. Tan to sell the room of 7 square meters of the house number 19 Thuoc Bac in case he dies. Since his family kept the transaction documents for the 202 rooms on the second floor of the house number 19 Thuoc Bac, his parents could sign these documents at any time. Mr. Tan's argument that his parents have not made the payment yet based on the absence of the signatures of his parents in the contract is incorrect. Mr. Nguyen passed away in 2000. Mr. Nguyen's wife being Ms. T Lam and Mr. Nguyen's children being Ms. Nguyen Din Yuan, Mr. Nguyen Din Hoa, Ms. Nguyen Din Hop, and Ms. Nguyen T Min Noyet confirmed that Mr. Chien was the one who bought the rooms on the second floor from Mr. Chow rather than Mr. Nguyen, who the nominee on behalf of Mr. Chien. Mr. Tan's family, living at the house number 17 Thuoc Bac, always caused difficulties for his family to live. Mr. Tan occupied the roof of the second floor of the house number 19 Thuoc Bac, so his father went over to talk with Mr. Tan not to use the roof, but Mr. Tan did not listen. Therefore, the two families made a written document which allowed Mr. Tan to jointly use the roof, but conflicts between the two families got worse over time. Afterwards, his family declared and transferred the ownership of the second floor of the house number 19 Thuoc Bac, but Mr. Tan always caused difficulties. Now, he requests the court to recognize the contract for sale and purchase of the second floor of the house number 19 Thuoc Bac. In addition, he had some requests as follows. Mr. Tan had already sold the first floor of the house number 19 Thuoc Bac to Mr. Teep's family and the second floor to his family. Therefore, Mr. Tan no longer had any rights as to the house number 19 Thuoc Bac, so Mr. Tan could not use the roof of the second floor and the ancillary area of the house 19 Thuoc Bac. When his family bought the second floor, his family and Mr. Tan had an oral agreement that allowed his family to use passageway through the first floor of the house number 17 Thuoc Bac of Mr. Tan to reach the street. Therefore, he requested Mr. Tan not to place objects in the passageway from the Hang California Street to the house number 17, the house number 19, and up to the second floor of the house number 19 Thuoc Bac. Requesting Mr. Tan to compensate for damage caused by his occupation of the roof and use of the passageway to place objects of an amount of VND 540 million, VND 2,500,000/month x 18 years. Compensation for injuries to him and his wife caused by Mr. Tan's children of VND 5 million/person. Compensation for mental loss caused by Mr. Tan to his family of VND 800 million. Mr. Tan placed his objects causing damage of the roof. Mr. Tan must pay for the roof's repair of an estimated amount of VND 120 million. The prolonged lawsuit against Mr. Tan caused him to lose his job, so Mr. Tan must pay VND 108 million, VND 12 million/year x 9 years. The defendant Mr. Du Trong Tan presented that Mr. Du Hui Nak and Ms. Lu Ti Hu, his parents, owned the house number 19 Thuoc Bac, which had land title number 1577, Dong Xian area, with area of 69 square meters. On April 21, 1959, the ownership of that house was transferred to their children in accordance with their will, namely, Mr. Chow was given 8/12 part of the house, other 4 children, Ms. Na, Ms. Noyet, Ms. Tone, and he were given joint ownership of 4/12 part of the house. In 1971, he and his siblings leased to Mr. Chien and his wife Ms. Mo, Mr. Song's parents, the second floor of the house number 19 Thuoc Bac. Then also in 1971, Mr. Chow sold entirely a room of 38 square meters of the house number 19 Thuoc Bac to Mr. Nguyen Din Nguyen, but Mr. Chien signed the contract for sale and purchase on behalf of Mr. Nguyen. The sale price was VND 6,550 and date of contract was not recorded. On September 9, 1972, Mr. Chow made a power of attorney for Mr. Tan to sell the room of 7.8 square meters on the second floor of the house number 19 Thuoc Bac. On November 5, 1972, Mr. Chow passed away. Based on Mr. Chow's power of attorney, the defendant made a contract for sale of the room of 7 square meters of the house to Mr. Chien, but Mr. Chien requested that he include the room of 38 square meters on the second floor that Mr. Chien had already bought from Mr. Chow, so the defendant made a contract for sale of the entire area in the 2N floor. His siblings signed the contract, but when he brought it over for Mr. Chien and Ms. Mo to sign, Mr. Nguyen was present there and scolded them. Mr. Nguyen did not allow them to sign it. As a result, they could not sign the contract. He disagreed with Mr. Song's request because Mr. Song only temporarily resided in Mr. Nguyen's house. Mr. Tan also had testimony. In particular, Mr. Chow had sold one room, but he only became aware of it in 1998, and at that time he learned that he owned a part of this house. Previously, he thought the house belonged to Mr. Chow. Mr. Chow authorized him to sell the room of 7 square meters. The sale and purchase contract noted that the buyer had received the house. The seller had received the money, but they agreed that the buyer will sign the contract before delivering the money. Mr. Chow authorizing him was wrong because this was the common property of his brothers and sisters. He had not declared the house number 19 Thuoc Bac, because it was still in dispute. He already registered the house number 17 Thuoc Bac, according to his inheritance under the judgment on the division of the estate in 1992. Mr. Chow made the contract for sale and purchase of 38 square meters of the house to Mr. Nguyen sometime in 1971. He only kept this original of Mr. Chow's sale and purchase contract to Mr. Nguyen while he did not keep the other documents. When Mr. Chow sold to Mr. Nguyen, Mr. Chow gave Mr. Nguyen the land title of the house number 19 Thuoc Bac to Mr. Nguyen. He did not agree with the request of Mr. Song because there was no transaction for sale and purchase of the second floor of the house number 19 Thuoc Bac, and Mr. Song's parents did not sign the contract for sale and purchase of the house, and did not make the payment too. The contract for sale and purchase of the house was not lawful, so Mr. Song had no right to claim the roof of the second floor. They only permitted the passageway through the first floor of the house number 17 Thuoc Bac that Mr. Song used, BL 586. Mr. Tan's brothers and sisters did not sell the rooms of the house number 19 Thuoc Bac, so he is still entitled to use it. He also did not accept Mr. Song's request for compensation for income losses due to the fact that Mr. Song was the disputing party, not him. After fighting, the two sides also had injuries and police officers did not resolve, so he did not agree to compensate. On April 7, 2009, Mr. Tan submitted a counterclaim to request Mr. Song to use another passageway to the street in the area of the house number 19 Thuoc Bac. In other words, the first floor of the house number 19 Thuoc Bac must have its own passageway for Mr. Song's family. The house number 17 Thuoc Bac belongs to him. When his siblings sold the first floor of the house at number 19 Thuoc Bac to Mr. Teep's family, they also stated clearly that the area being sold was the current living area, except for the passageway. On September 23, 2009, Mr. Tan submitted a petition to withdraw the counterclaim on the passageway. Ms. Du T Noyet's and Ms. Du T Na's children being Mr. Vong Chi Tuong, Mr. Vong Chi Tang, Ms. Vong Bich Van, and Ms. Vong Bich Hop presented. The of 38 square meters sold by Mr. Chow was jointly owned. Mr. Chow had no right to sell it. Ms. Na and Ms. Noyet had sold the room of 7 square meter to Mr. Chien, but as the buyer did not make the payment yet, so they requested the return of the house. Persons with related rights and obligations. Ms. T Lam presented. Her husband is Mr. Nguyen Din Nguyen, passed away in 2000. Previously, she and her husband lived in the house number 10 Heng Bun Street together with Mr. Chien and his wife. In 1970, Mr. Chien and his wife moved into the house number 19 Thuoc Bac. She did not know how Mr. Chien and his wife purchased the house, but she remembered that, in 1972, Mr. Nguyen told her about the purchase of a house of Mr. Chien, and Mr. Chien had asked him for being a nominee in the transaction. The house number 19 Thwakbak was totally purchased by Mr. Chien and his wife, and her family did not engage in the transaction of the house with Mr. Tan. Her family also did not have any interest regarding the house number 19 Thwakbak. The children of Ms. Lam being Mr. Nguyen Din Yuan, Mr. Nguyen Din Hoa, Ms. Nguyen Nguyen Hop, and Ms. Nguyen T Min Noyet presented their agreement with Ms. Lam's testimony. Ms. Tran T Bitch and Mr. Vu Din Hao presented. They live on the first floor of the house number 19 Thwakbak. Mr. Tan did not have any right to request them to open a passageway for Mr. Song's family on the second floor. Mr. Tan submitted a petition for the withdrawal of the counterclaim against the passageway, and they had no further opinion. In first instance civil judgment number 78/DSST, on November 21, 2007, the People's Court of Hanoi ruled to reject the request of Mr. Nguyen Din Song. On November 21, 2007, Mr. Nguyen Din Song submitted an appeal. In appellate civil judgment number 121/2008/DSPT dated on June 30, 2008, the Appellate Court of the Supreme People's Court in Hanoi ruled to set aside the first instance judgment and transfer the case to the first instance court to reconduct resolution of the case. In first instance civil judgment number 52/2009/DSST dated September 29, 2009, the People's Court of Hanoi ruled 1. To not accept the request of the plaintiff to recognize the contract for sale and purchase of the entire second floor of the house number 19 Thwakbak. 2. To accept the request of Mr. Song to compel Mr. Tan to clear objects, ornamental plants on the second floor of the house number 19 Thwakbak and move them back to the house number 17 Thwakbak. Mr. Tan's family and Mr. Song's family shall use the roof of the second floor of the house number 19 Thwakbak as the commitment signed on December 20, 1987. 3. To not accept Mr. Song's request on prohibiting Mr. Tan's family from using the rooms and the roof of the house number 19 Thwakbak. 4. To determine that the passageway from Hang California Street up to the second floor of the house number 19 Thwakbak was on the two land areas of the house number 17 and the house number 19 Thwakbak. Therefore, it is prohibited for anyone to place goods or objects which may obstruct travel. 5. To not accept Mr. Song's requests for compensation caused by Mr. Tan. 6. To reject the other requests of the involved parties. 7. To suspend the resolution of the counterclaim of Mr. Tan. On October 1, 2009, Mr. Nguyen Din Song submitted an appeal to disagree with the first instance court ruling. On October 12, 2009, Mr. Du Trong Tan submitted an appeal to disagree with the first instance court ruling regarding the passageway and requested the court to determine that the passageway was just temporary. Under Appellate Civil Judgment number 86/2010/DSPT dated May 18, 2010, the Appellate Court of the Supreme People's Court in Hanoi ruled to uphold the first instance judgment regarding the settlement of the contract for the sale and purchase of the house and other requests, to set aside parts of the first instance judgment and transfer the case file to the first instance court to reconduct settlement regarding the passageway through the house at number 17 Thwakbak. On July 20, 2010, Mr. Nguyen Din Song submitted a request for cassation review requesting recognition of contract for the sale and purchase of the second floor of the house number 19 Thwakbak. In decision number 148/2013/KNDS dated April 11, 2013, the Chief Justice of the Supreme People's Court protested against Appellate Civil Judgment number 86/2010/DSPT dated May 18, 2010 of the Appellate Court of the Supreme People's Court in Hanoi. Requested the Judicial Council of the Supreme People's Court to review the case under cassation procedure to set aside the above-mentioned appellate civil judgment and first instance civil judgment number 52/2009/DSST dated September 29, 2009 of the People's Court of Hanoi, transferred the case file to the People's Court of Hanoi to reconduct the first instance procedure in accordance with law. In the cassation hearing, the representative of the Supreme People's Procuracy requested the Judicial Council of the Supreme People's Court to accept the protest of the Chief Justice of the Supreme People's Court, but in the direction of setting aside Appellate Civil Judgment Number 86/2010/DSPT dated May 18, 2010 of the Appellate Court of the Supreme People's Court in Hanoi, and transferring the case to the Appellate Court for reconduct appellate procedures. Part 4. Assessment of the Court. The Judicial Council of the Supreme People's Court finds, based on the testimonies of the plaintiff, the defendants, and documents in the case file, the house number 19, Thuoc Bac Street, Hang Bo Ward, Hon Kien District, Hanoi, owned by the husband and wife Mr. Du Hui Ngoc and Ms. Lu Ti Hu, was transferred to heirs including Mr. Du Trong Chow, passed away in 1972, no wife and children, who was given 8/12 parts of the house, and Ms. Du Ti Na, Ms. Du Ti Noyet, Ms. Du Ti Song Ton, passed away in 1963, no husband and children, and Mr. Du Trong Ton, who together were given 4/12 parts of the house. On July 1, 1971, Mr. Ton signed a contract with the family of Mr. Nguyen Din Nguyen, the uncle of Mr. Nguyen Din Song, who passed away in 2000, and Mr. Nguyen Din Chien and his wife, the father of Mr. Song, who passed away in 1998, for leasing the room on the 2th floor of the house number 19 Thuoc Bac with the area of 39.36 square meter for money for medical treatment. He received VND 2.000 in advance. At the document for complete sale of rooms, no date recorded, but Mr. Ton acknowledged that this document was written around 1971. Mr. Chow had already sold to Mr. Nguyen a room on the 2nd floor of the house number 19 Thuoc Bac, no area recorded, for an amount of VND 6,550. The seller received payment in full, and it was noted that Mr. Chien represented and signed on behalf of Mr. Nguyen. Mr. Ton asserted that the sold room was the aforementioned leased room, and he sold it to Mr. Nguyen rather than Mr. Chien. However, Ms. T. Lam and Mr. Nguyen Din Yuan, Mr. Nguyen Din Hoa, Ms. Nguyen Nguyen Hop, Ms. Nguyen T. Min Noyet, Mr. Nguyen's wife and children, confirmed that Mr. Chien directly transacted and made payment. Mr. Nguyen was only a nominee for Mr. Chien on the contract for sale and purchase of house sold by Mr. Chow. Therefore, there is a basis to determine that Mr. Chien was the buyer of this room. On September 9, 1972, Mr. Chow made a power of attorney authorizing Mr. Ton to sell the room in which Mr. Chow was staying. On November 5, 1972, Mr. Chow died without leaving a will. Also, on November 5, 1972, Mr. Ton, Ms. Na, and Ms. Noyet signed contract of sale and purchase of the entire 2nd floor of the house number 19 Thuoc Bac, having the contents of selling to Mr. Chien and his wife the main room 38.07 square meter and auxiliary room 7.095 square meter, the total of 45.165 square meter. With price of VND 3,000, the seller already received the payment in full. The buyer had already received the 2nd floor of the house and was living there. The contract had 3 people including Mr. Ton, Ms. Na, and Ms. Noyet as the sellers who signed, and the buyers being recorded as Mr. Chien and Ms. Mo did not sign. When the dispute arose, Mr. Song presented 2 contracts for sale and purchase of the house as mentioned above, and the power of attorney of Mr. Chow authorizing Mr. Ton to sell the house. In fact, Mr. Chien's family had already managed 2 rooms on the 2nd floor of the house number 19 Thuoc Bac of Mr. Ton's family since 1972. Mr. Ton's family living at the adjoining house number 17 Thuoc Bac did not have any disputes regarding rental or payment. The contents of the contract of sale and purchase of the entire 2nd floor of the house number 19 Thuoc Bac Street clearly stated that the seller received money in full, and there was no agreement that the parties would produce separately any receipt of payment, and the contract was also the receipt which the seller confirmed the payment in full from the buyer. The buyer did not yet sign the contract for sale and purchase of the house, but this contract is to be kept by the buyer, thus, it can be used to prove the seller's obligation regarding its receipt of payment in full. The first instance and appellate courts asserted that the buyer did not yet sign the contract for sale and purchase of the house, and could not prove that full payment was made, thereby dismissing the plaintiff's request for recognition of the contract for sale and purchase of the house. This did not ensure the rights of the plaintiff. The transaction for sale and purchase of the house between the siblings being Mr. Tan and his sisters and the couple being Mr. Chien and Ms. Mo entered into before July 1, 1991, so Resolution Number 58/1998/NQUBTVQH10 on August 20, 1998 of the Standing Committee of the National Assembly shall be applied to settle the case. Ms. LUient T Lan, the daughter of Mr. Chien and Ms. Mo, participated in the proceedings as a person with related rights and obligations, because she inherited the estate of Mr. Chien and Mr. Mo without participating in this transaction. Since Ms. Lan has been living in the Czech Republic from 1997, this transaction is not a transaction of house entered into before July 1, 1991 with the participation of people residing overseas before July 1, 1991. Therefore, the First Instance Court and Appellate Court applying Resolution Number 1037/2006/NQUBTVQH11 dated July 27, 2006 on civil transactions of house entered into before July 1, 1991 with the participation of Vietnamese residing overseas to resolve this case is not quite correct. For the above reasons, pursuant to Articles 291.3, 297.3, and 299.2 of the Civil Procedure Code, as amended and supplemented under Law No. 65/2011/QH12 dated March 29, 2011 of the National Assembly. 1. To set aside in its entirety Appellate Civil Judgment No. 86/2010/DSPT dated May 18, 2010 of the Appellate Court of the Supreme People's Court in Hanoi on the case named Disputes on the Rights of Ownership and Use of House between the plaintiffs being Mr. Nguyen Din Song, Ms. Nguyen T Hong, and Ms. Nguyen T Hong, and the defendants being Mr. Du Trong Tan, Ms. Du T Noyet, Mr. Vong Chi Tuong, Ms. Vong Bich Van, and Ms. Vong Bich Hop. Persons with related rights and obligations include 9 people to transfer the case to the Appellate Court of the Supreme People's Court in Hanoi to reconduct the first instance procedure in accordance with law. When the dispute arose, Mr. Song presented 2 contracts for sale and purchase of the house as mentioned above, and the power of attorney of Mr. Chow authorizing Mr. Tan to sell the house. In fact, Mr. Chien's family had already managed 2 rooms on the second floor of the house number 19 Thuoc back of Mr. Tan's family since 1972. Mr. Tan's family living at the adjoining house number 17 Thuoc back did not have any disputes regarding rental or payment. The contents of the contract of sale and purchase of the entire second floor of the house number 19 Thuoc back Street clearly stated that the seller received money in full, and there was no agreement that the parties would produce separately any receipt of payment, and the contract was also the receipt which the seller confirmed the payment in full from the buyer. The buyer did not yet sign the contract for sale and purchase of the house, but this contract is to be kept by the buyer. Thus, it can be used to prove the seller's obligation regarding its receipt of payment in full. The first instance and appellate courts asserted that the buyer did not yet sign the contract for sale and purchase of the house, and could not prove that full payment was made, thereby dismissing the plaintiff's request for recognition of the contract for sale and purchase of the house. This did not ensure the rights of the plaintiff.